station, its staff, management, or sponsors.
Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon. This is the Ask the Experts radio show. We are on, now we've got this whole list now. We are on 96.9 FM. I'm doing this off the top of my head. 96.9 FM, 95.3 FM, 103.9 FM, our big mother station, 1470 AM, and we're also on the iHeart app, and the TuneIn app. So there's a lot of ways you can listen to the show. You can actually go watch the show several ways too. You can go to our Facebook and watch it on Ask the Experts, host and Renee, or just, I'm sorry, I'm so used to saying Renee, Steve-O, or you can go to Kaye Bender's website and watch the show, or you can just sit back and listen. This is our community association show today with our good friend Robert Kaye. He's one of the senior partners of the firm with 3 locations: Pompano, Palm Beach, and the new location in Tampa. You're growing.
Yes, we keep on growing. Good afternoon, everybody.
So good to see you. I've been out for a couple months, but this is the easiest show to do. Get your phone calls ready. The phone number here is 888-565-1470. That's 888-565-1470. If you've got a HOA or a condo association question. Plus, we get so many people writing us that I give the questions to Robert to answer. And I got to tell you, don't get a big head. We get so many emails with questions, but most of them all say how much they love your show, Robert.
Well, we appreciate the kindness and the words that they have expressed in that regard, and we'll keep on trying to keep everybody happy.
You do such a great job. Hey, you know what? Tell everybody about the firm.
Well, Kaye Bender Rembaum is a full-service firm specializing in the area of community association law, as you've identified. We have, as you said, offices in Pompano Beach, Palm Beach Gardens, and Tampa, providing the legal guidance to community associations throughout most of Florida. We cover all aspects of the day-to-day legal issues that associations face, enforcing covenants, interpreting covenants, addressing maintenance issues, addressing contract issues, collecting unpaid assessments, advising as to updates in the laws as they occur, both statutorily and in case law, and generally being on top of things that any association will face on a day-to-day basis. We also, as you are fond to tell everybody, also provide continuing education to property managers and board members and the general public. We've been a little hampered this year because of the conditions and the inability to get people together in groups, but we are doing certain webinar things. You can find out all of those on our website at kbrlegal.com. I'm also instructed to tell everybody, if you're interested in attending any of these and you want to be in our email blast, send your information to info@kbrlegal.com, and we will add you to the list of those who are getting updates on a regular basis as to new shows as they're happening and the ones that are already scheduled.
Well, I've got a little surprise for you. All the
Yes,
lines are booked right now because you and I can't see them. So let's try to see if Sven is there on line one.
Sven.
Yes, I am. Good evening.
Hello,
Hey,
Sven.
Sven, how you doing?
I'm doing well. How are you?
We can hear you
Good so
fine.
I
far.
have a question about condominium associations.
Go
Can a
ahead.
condominium association um, start a capital um, contribution policy without changing the documents?
Uh, General answer to that would be no. To be able to charge a capital contribution, the authority to do so would need to be in your declaration of condominium. You should also keep in mind that the division of condominium takes a very narrow view of the capital contributions, which we think is not exactly correct, but the division position is that a capital contribution amounts to a transfer fee, and the transfer fee is limited to $100, and usually
Right.
that's for the application. Capital contribution is typically a month or two or three of assessments, and that the association just puts in the bank to help it offset its basic costs. If it's in the
So that
declaration,
policy, to be able to do that, has to be in the condominium documents in order for the board to collect capital contributions from new buyers.
correct.
Okay. I have another question about condominiums. Recently, I read that there was a court case. I don't believe it was in the state of Florida. It was in another state where a buyer had made a suit against a condominium association complaining about providing tax returns, that it was an unnecessary invasion of the buyer's financial uh, information, and the judge ruled in favor of the plaintiff in that he did not have to provide tax returns for a condominium association approval.
Well, Sven, the case you're referring to is a Florida case, but it's a circuit court case. And that circuit
What
court
kind of
case
case?
is, it's a circuit court, it's the lower court. And
Okay.
the county court is the lowest, circuit court is second, district court of appeal is third, Supreme Court is fourth. The circuit court and the county court do not have what's called precedential value. In other words, the decisions of those courts only apply to the parties. They're not applicable generally as the state of the law. You need an appellate decision from either the district court of appeal or the Supreme Court. So one circuit court judge issued a ruling, and it was on the west coast of Florida, that the request for tax returns, in that judge's opinion, was an unreasonable requirement. If that requirement's in your declaration of condominium, then reasonableness is not an issue that the judge can take into account. The only way the judge could say that's not allowed under the law is if the judge determines it to be against public policy or arbitrary and capricious, which are very high standards that generally would not apply. And if a judge did that, it's in all likelihood on appeal that would be overturned. Tax returns are quite often part of what associations ask for. And other than this one circuit court case, I've not seen any decisions of courts that have held otherwise.
Okay. All right. Well, thank you very much for your answers to my questions.
Thanks for
Thanks, Sven.
listening.
Let's
Okay.
go to line two. Herb, are you still with us?
Thank, Counselor, thank you for taking my call. You can
Sure.
hear me, I hope?
Yeah, we
Yes,
can hear
sir.
you fine.
Okay, that's good. The question that I have pertains to legal issues under Florida Statute 718, whereby the only time meetings can be closed, board meetings, is when it there are 3 criteria, whereas the board in our association, for whatever reason, closed 3 board meetings, calling it a legal meeting when there is no such definition in the statutes. And the reason this came about was the supposed opening of the condominium pool. And I objected to the closed door meetings. The lawyer was in agreement that it was a legal matter and it couldn't be discussed. Were they going overboard on their definition in terms of the 3 criteria? There was no proposed litigation, no pending litigation, and it did not pertain to personnel matters. I'd like your opinion.
Was the lawyer physically present?
Yes.
Okay. I think that while you may disagree, the lawyer may have concluded that it could be under the umbrella of potential litigation by virtue of the fact that there are differences of opinion as to interpretations of various orders that the counties have enacted and how they apply to the functionality of some of the common elements and have through the months. And having these discussions with the attorney is a privileged conversation. So while it's probably more in the gray area than one of black and white, they probably were erring on the side of caution and maintaining the privilege with their attorney in that particular meeting. If you challenge that as improper, it's possible the division would agree with you. It's possible they would not. I think this one is kind of a close call.
Well, you threw in another adjective. You used the word potential. Florida statute says proposed and pending, not potential. There was no such situation.
It's been applied as potential litigation. Proposed and potential tend to be synonymous when it comes to that particular issue.
Okay, I was taken literally from the law, but that's why there are attorneys, I guess, and judges.
I hear you.
Thank you, Counselor. I appreciate
Thanks, Herb.
it. Have a good day.
Thanks for listening.
You too, bud. Hey, we got to go to break. When we come back, we've got Jeff and Barry, and we got a calendar we got to go through of classes that are going to be coming up. Let's go to break. Give everybody the phone number at the office.
Well, you can reach us at 1-800-974-0680 for all 3 offices.
Perfect. We'll be right back with Robert Kaye of the Kaye Bender Rembaum Law Firm.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. This is the Ask the Expert show. We're on every Monday and Thursday from 6 to 7. The first Thursday of the month is the Kaye Bender Rembaum. They are association attorneys, community association attorneys with offices in Pompano, Palm Beach, and Tampa. And we have one of the principals. We've been doing this show for about 3 years, and he loves answering your questions. Phone lines are crazy today. Let's go to Jeff. He's been holding for a while. Hi, Jeff.
Robert. I have been living in a townhouse complex, 9 units, for the past 2 years. And in the last month, a retiree who claims he's about 53 years old has come down to live permanently right next door to me. We have a common wall, so he's right next door to me. And he has a terrible practice of playing very, very loud music till all hours of the morning. 2, 3, 4, 5, 6 o'clock in the morning. And so I texted him when he did it the first time, and he ignored me completely. I didn't get any sleep that night. He did it on Sunday morning. It carried on all night. I did text him. He did not reply. I then texted again, and after texting him at 2:30 in the morning, asking him to please turn down the sound, at 5 a.m. he replied saying, "Sorry, I didn't think it was loud." Now, my question is, how do I put a stop to this highly invasive practice that invades my privacy and disturbs my peace?
Well, Jeff, is there a unit on the other side of him or just you?
Repeat that, please. I didn't catch it.
Is there another unit on the other side of this noisemaker?
No, I'm the end unit, and then his unit is next to mine.
And there isn't anyone on the other side of him?
There is, but that person's not as close as I am, because my bedroom backs onto his bedroom, my living room backs onto his, and so the configuration of the other neighbor is not as bad. Apparently, he doesn't hear what's going on.
Right. So if you're the only one who's affected, then the issue falls to you to address. The statute and your documents give you the authority to bring legal action against your neighbor to eliminate the source of this noise problem and the nuisance that's been created. Have you tried calling the police at all at these odd hours?
I have not. I thought I'd speak to you about it first.
Well, calling the police builds a record, which is helpful. If you're going to try and take legal action, you're going to need witnesses. You're going to need evidence of the noise levels, which would probably require some form of expert assistance from some form of a sound engineer who can get you decibel levels and things of that nature. The association can send a letter indicating that this is causing you a nuisance and ask him to be more aware and considerate of his neighbors and see if that works. But as far as actual legal action to compel the nuisance to stop, that would fall to you.
Okay. So my next course would be to call the police.
Call the police as it's happening. It's probably not a good idea for you to have a confrontation, although if during normal hours you might want to speak to the person and let them know of this problem other than texting, if you can work it out between you, that's ideal. If he's just not interested in that, then you have to go to the more serious approach.
Hey, Jeff, do you want me to slit his tires for you?
Absolutely not. That would not help at all.
No, there'd still be a lot of noise in the middle of the night.
Yeah. True.
Does that answer your question?
So let me just recap here for one moment, please, just to get my bearings. So if I call the police, what do you happen to know what time the city of Fort Lauderdale regards the noise ordinance as being breached?
I believe it's 11 p.m.
Yeah,
11 p.m. for weekends as well?
yes.
I believe so, yes.
Okay, I'll have to confirm that. Well, you certainly have addressed my concerns, and I appreciate that very much. Thank you.
No, Jeff,
Thank
I'm
you
sorry
so
you're
much.
going through that, but thank you for listening.
It's dreadful.
I can't imagine.
You know, for 2 years I had peace and quiet from the previous neighbor. This fellow now, he's a 53-year-old child. He wants to party all day, every day, and night.
It's amazing.
Wow.
He should live in a house by himself.
Yep.
Exactly. But, you know, he's bought this place and he's not going away anytime soon.
All right, well, good luck with that, Jeff.
Thank you.
I just want to get Barry's been on hold for a long time. Barry, are you
Sure.
still there?
I'm still here.
Barry?
And Mr. Kaye, since you're the founding partner of the firm, I have a way for you to increase your size by 50%. Can
Go
I tell
ahead.
you how to do
Okay.
it?
Sure.
Yeah.
I don't
change
think
your
so.
ad. Your ad said you have 800 clients. Michael Bender on a webinar last week, said you have over 1,200 clients.
Where did you see the 800 number? On the website?
No, on the ad that just played at the break.
Oh, it's an
It's
old
an old
ad,
ad.
yes.
Yeah. So
You
you
hear
can
that,
go
Steve?
from 800 to 1,200, increase by 50%. But you got to answer my question.
Go ahead.
Okay. I'm only joshing you too. We have a limited proxy vote next week to amend our declaration. We do not have electronic voting, but they are going to use DocuSign, and you can explain that, but that's basically an electronic signature. And
You've
one of the
explained it.
requirements under the electronic voting is to have an identity authentication. And DocuSign has 4 methods of passwords and things like that for identity authentication. But we're not using them. And my concern is that DocuSign is an end run around 718.128 and the electronic voting platforms that we see for voting. That's my question.
So your question is it?
Can you use DocuSign for a limited proxy, or because it doesn't meet all of the 718 rules for electronic voting, does that give us a problem in trying to use it? Because if we can use it there, then we could probably use it for our annual election, and it has less requirements than the 718.128 requirements.
Well, you can use it for a limited proxy because Florida has laws that provides for electronic signatures and the validation of that. It's not the same as an electronic voting procedure, and you could not use it for the election of directors because you cannot use proxies for the election of directors. You have to use the ballot process.
Right.
So you would need to
Right.
comply with the procedural requirements of 718 on the electronic voting in order to have
But
your
they're not.
annual
They're
election
not.
that way.
One of the requirements is to have a unit owner authentication method, and they're not using any of them, which are passwords and things like that.
Right. Yeah, at this point, I think it's probably not a safe approach other than using it just for a limited proxy purpose.
Well, I'm a little confused. That's all we're going to use it for is limited proxy. It's not an annual election.
I think that's sufficient. That's not electronic voting. Not as the
Okay.
statute considers it. It's just submitting a proxy electronically. I know it sounds like the same thing,
Okay.
but it's technically different.
Okay. Thank you so much.
Thanks a
All right,
lot.
and thanks for pointing out the need to update our ad.
Oh, can I just mention one other thing? And I
And
don't want you
also
to go into it, but an article you wrote on material alterations and the Shelbourne case was the best article I've read on condominium law in the last 5 years.
thank you very much.
Who wrote
And
it?
there's a lot of reasons for it, but your
Me.
safety valve suggestion, and you can go into it, is something that no other lawyer mentions.
Which was that?
So that's, I'm sorry?
What were you referring to?
Well, you call it, basically you're saying you can have a vote by the unit owners after the material alteration project has commenced. And you're saying that if it's in your declaration, the law that passed 2 years ago that says the vote has to be taken before the project begins doesn't apply. And so if you have a material, what the board thinks is not a material alteration, they think it's a repair, or they think going from one carpet color to another isn't a material alteration, they think you have to go from carpet to tile or tile to carpet, at least you can have a safety valve that lets the vote be taken afterwards.
There is a lot of discussion among the attorneys practicing throughout the state about the way that case came out, and in fact, the inclusion of that language in the statute a couple of years ago seemed to be misguided. It doesn't make sense to put an association in a position that does not allow for a subsequent ratification vote by the owners. The case that was decided by the Third District Court last month had a very unique set of facts that wasn't completely spelled out in the decision, but the attorney who was involved in that case has explained a little more details about it. And the board was a little bit underhanded in what they were doing by virtue of having a great percentage of ownership throughout the condominium. So it was unfortunate that the circumstances led to an appellate decision that may be more far-reaching than it should be when it comes to that issue of after the fact ratification. But I don't think we've heard the end of that.
Okay. Thank you very much. Appreciate it.
Thanks so much.
And thanks for calling.
Well,
Sure.
we've had some unusual questions today, huh?
Yeah, they're good.
Let's go to break.
So before we take a
back.
break,
Yes.
I was going to suggest maybe telling you what's upcoming before we do that.
Oh, you want to do it before we go to break? That's fine. We also have a lot of callers waiting too.
Yes, and we want to talk to them. But next week on August 11th at 11 o'clock, there will be a webinar that we're doing in conjunction with Affinity Management. Lisa McGill will be discussing emotional support animal legislative update from 11 o'clock to noon. Go to our website for sign-up information at kbrlegal.com. And then on Thursday the 13th, in conjunction with the Castle Group, Jeff Rembaum and Lisa McGill will be involved in a webinar from noon to 1 o'clock, ongoing association operations during the COVID-19 issues. And there's question and answers that go on, which is hosted by Campbell Property Management. There's also going to be a participant covering insurance issues as well, and be moderated by Chris Vaughn at Castle Management. Then on August 18th at 1 o'clock to 2:15, there's a legal update that will be presented by Allison Hurst of our Palm Beach Gardens office. On August the 26th at 10 a.m. to 11:20, it says, we have a 40-year recertification course that Lisa McGill will be presenting on a webinar that will be available through our website, kbrlegal.com. The 40-year recertification is a big issue for a lot of communities and condominiums from the 70s and 80s. They're going to have to address those issues. That's a very important webinar that everybody should be seriously considering. And August 27th, noon to 1 p.m., another Castle group with Michael Bender and Jeff Rembaum and Craig Vaughn with the ongoing COVID-19 issues.
Wow, you got some good ones coming up.
And that's just August.
Wow. Okay. Well, we're going to go to break, and hopefully Jack and Alan are still on hold. I promise you we'll
Hang in
get
there,
to you
guys.
as soon as we come back from break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
And we are back. This is the Ask the Expert Show. We're on every Monday and Thursday with local experts from 6 to 7 p.m. This is the first Thursday of the month, so that means Kaye Bender Rembaum. Your call, we just got a board full of calls now. Let's see if everybody's still there. Is Jack still there?
Sir.
Jack?
Yes, am I on?
You're
Yes.
on.
Okay, great.
Say hello to Robert
Thank
Kaye.
you for taking my call, first of all.
Yes, sir.
I would like to ask Mr. Kaye, I feel I'm being discriminated in my HOA by the Violations Committee. And I asked a couple months ago to see the violations letter that they sent out. And Mr. Kaye suggested that they were requestable. However, the board president stated that they are not. And I tried to look in 720, the statutes. I could not find anything pertaining to the violations notices. So I wonder, do I have any recourse, or should I just stop here?
Well, you're talking about violations that the board may have sent out to other homeowners of any types
Correct.
of violations.
Correct.
They're saying those are not
Right.
open to your inspection. That would be an incorrect statement. Those are written documents that are part of the association official records that are not otherwise accepted from being available to the inspection of a requesting homeowner, which you qualify as. Unfortunately, the only avenue of addressing when the board is acting improperly in a homeowner association withholding records is you have to file a lawsuit.
I have to file a lawsuit to see them?
If the board continues to withhold the records, there is no administrative body that will oversee that type of violation like there is for condominiums in the division of condominiums. Homeowner associations do not fall under that jurisdiction, so the only available avenue of recourse on that is to bring an action probably in the county court for the relief that you need. And you may want to get an attorney involved to help you out. Your attorney's fees and costs would also be the responsibility of the association as you prevail on something like that. Plus, you'd get statutory damages.
Okay. And another
But if an
question:
attorney writes to them,
if we have, uh-huh.
I say, and sometimes when an
Another
attorney writes to the
small
board,
question.
they gain understanding.
Yeah. So I do have a right to request to see those letters.
Yes, the request should be for an appointment to access and inspect, not to have them make copies and send them to you.
No, inspect, of course. Yes.
Yes.
And another question, Mr. Kaye, is it is a self-governed HOA, and the violations committee is strictly made up of board members. So residents have tried to get on it. They will not allow anybody to access the committee. Is that legal?
If it's just a violation committee that identifies violations and sends violation letters, that's within the law. If it's a committee that approves fines that the board adopts, then that would be wrong.
Okay. All right. Thank you so much, Mr. Kaye. I appreciate it.
All right.
And keep up the
Thank
good
you for
work.
listening.
A lot of people listening. Thank you. Bye-bye.
Yeah. Hey, Robert, I want to ask, this is really a good question right here. A listener lives at a country club. They pay HOA dues. The kitchen is closed due to the virus. Why do they have to continue paying if services aren't being rendered?
Well, that's because that's the way the law is in Florida. If there is a community association and it has the power to adopt periodic assessments, which is the case here, the obligation to provide services has been considered a separate covenant or obligation than that of the obligation to pay assessments. The owners have to keep paying even if services are not being provided. There are avenues of recourse if the services are not being provided. Under current situations, because of the COVID-19, I don't know how much benefit there's going to be, but the association has expenses regardless of whether or not they can continue to serve food and have people coming into a restaurant setting. And unfortunately, the assessment payment requirement remains intact regardless of whether or not the services are being performed, at least on a temporary basis.
Gotcha.
Now, it's possible the board could at some point give everyone a credit, but that's up to the board.
Okay. Is Alan still holding? Alan, are you still there?
I'm right here.
Oh, good.
Hello, Alan.
Hi, Alan. Thank you for holding.
Okay, my pleasure.
So you got a question for Robert?
I do. I actually have two questions. Hopefully one
No
will
extra
be very
charge.
quick. Okay. With regard to the recent changes with regard to accommodating emotional support animals. Now, I realize that there is a system for requesting this accommodation, and it requires a letter from a doctor who has actually examined the applicant. So my question is, how often does that accommodation have to be renewed? Or is there no time limit? If one gets a accommodation and it's approved, is that forever?
Well, it's more of a factual determination. Generally speaking, there's no provision in the law for renewal. So it would need to be a fairly obvious indication that the need is no longer there. Unfortunately, in most of these situations, the need is not an obvious situation to begin with, emotional issues and anxiety and things of that nature are not something you would necessarily be able to tell by looking. And so, as long as that owner or resident is still living in the property, then the accommodation continues. Now, there is another issue of what happens if the animal passes. Can they replace it automatically? And they would have to again apply at that point, because one of the requirements is that the specific animal has to alleviate the issues, not just any animal. So uh, that might be an instance in which a renewal would be required.
I see. Well, I want to thank you very much for that. My second question is with regard to, and I must apologize, this is my first time listening to you and first time calling in. So I may
You're
be
doing well.
asking questions that have been previously answered. I apologize for that.
It's okay.
No
My
problem.
question concerns, okay, my question concerns material change. In our declaration and documents, there is nothing listed. We are a 40-plus-year-old condominium. And so there was nothing listed over the years with regard to material alteration. And recently, I think one of your previous callers today mentioned material change, and as a matter of fact, applauded you for an article that you obviously wrote that I'm sorry I didn't get a chance to read. But it
But you
seems
can
as
find
though
that on our
now,
website.
yes, and I'll be able to find it there.
Yeah, under
Yes.
the heading of legal morsels, it's available on the website, kbrlegal.com.
Excellent. Excellent. My question is this. According to Section 718, I believe that material change requires a 75% unit owner vote in favor of whatever the board has approved for or intending to as a material alteration. If your documents have nothing with regard to material alteration, is it assumed, and I know nothing is supposed to be assumed, but I'm, for no better word at the present time, I'm going to use the word assumed. Is it assumed then that if a need for a material alteration is necessary, would be necessary at a 75% rate?
Well, the way the statute is written is that if the documents do not contain a provision or are silent on the issue of owner approval, then 75% of the owner vote is required in advance of undertaking the material alteration. But there is an exception in case law if the material alteration constitutes necessary maintenance on an item within the property that is the association's obligation to maintain, then no vote of the owners is required. An example could be, let's say, the community's on a beachfront property and you're having some erosion issues. So the board decides we're going to have to build a seawall to help maintain our property. That's something that wasn't there before, clearly a material alteration to the common elements. But since it's necessary to maintain the rest of the property and protect it, the courts have determined that to be an exception that does not require a vote of the owner. So you have to know for sure what it is you're talking about as to the specific issue of change, whether or not it falls within the exception that may not require a vote of the owners.
Right.
So think in terms of if you're putting something there
Sorry.
that wasn't before, you're adding parking spaces to a spot that used to be grass. If you're changing your roof material from a shingle to a barrel tile, that is considered material alteration. It's not maintenance, it's requiring a vote. Unfortunately, even the
Right.
change in color of the building has been decided by the division to be a material alteration, even though that's a misinterpretation of case law.
Well, it's apparent to me as a layperson that some of the upcoming projects are absolutely material alterations. When you're going from balustrades on a balcony to glass enclosures, to me, that's material change. So
Yes, I agree.
let me just assume for a moment that what I'm calling about is material alterations. My question basically is this. If the declaration, and the original declaration says that you can amend your documents with a 51% vote up by the unit owners, in addition, of course, to the directors voting in favor of it first, my question is, if that's in your documents and you have nothing with regard to material alteration, but you do have in the documents the fact that it relies upon Section 718, which may change from time to time. I believe that those are the customary words that are used or something to that effect. Now, if you're now going to do a material alteration and the state requires a 75% unit owner vote toward the material alteration, can you now amend and call for a 51% vote? In other words, to change from 75% to 51%, which is more reasonable in terms of getting a positive vote. Is that something that's done, or is that absolutely something that's questionable?
No, it absolutely can be done. In fact, it's allowable to amend your declaration to eliminate owner vote requirement 100% and give the board the authority to do it on its own. So you have a lot of options based upon your amendment entitlement.
I see. Well, I want to thank you so much for your time, and I appreciate your answering. Okay?
Well, thanks for finding us,
well
and
and safe.
we're here every month.
Okay. Thank you.
So, Robert, we had a few people who couldn't hold any longer. One of them wanted to know if, I guess she is in a small condo association, and she wanted to know if they can't get any board members, do they have to get a receiver? But a receiver is supposedly really expensive.
Also true, yes. In this situation, that there's no willing volunteer from among the owners to serve on the board, and it has to be an owner to be on the board, then the statute provides the ability for any unit owner to petition the court to have a receiver appointed who will act in the place of the board. And that can be expensive because the receiver's time is billed to the association in whatever amount they deem appropriate. It could be $175 an hour, it could be $250 an hour. It'll be subject to court approval, which the court generally will grant. And however many hours a month they spend in operating the community, everybody has to pay for. So there's a good reason to get a volunteer of board members to serve. One other alternative they could do is amend their requirements and their documents to eliminate the requirement of members or owners to qualify to serve on the board, and then maybe they could bring in some outside people to act as their board. And maybe if they have to pay them a small amount to do that to keep them interested, or allow some renters to serve on the board, or spouses of owners, they may increase the amount of available board members by doing that. Otherwise, receiver is the only option, and there needs to be somebody running the ship.
Right. Okay. I noticed, I don't know if it's because there's a lot of people out of work right now, but I noticed a lot of the questions were about not paying dues, but the questions were confidentiality and not having names for everybody to see. How does that work?
Well, we generally recommend it's not a good idea to name names at board meetings of people who are delinquent. It's available to any unit owner who wants to inspect the official records to see all the accounts of all the units to see who's delinquent and who isn't. It's certainly okay for the board to indicate that there are units that are delinquent and the amounts that they are. But it's generally recommended not to name names, not to post a list in the community of delinquencies. There are privacy issues that come into play. There's potential issues of perhaps the records are in error, and you've created a situation for somebody that it adds additional exposure for liability to the association. So it's best to avoid making those types of announcements. When it comes to covenant violations, that's a different situation that would not necessarily need the same level of confidentiality.
Okay. Hey, we only have a few minutes left. Do you want to go over again your schedule for this month?
Sure. All on webinars this month. On August the 11th at 11 a.m. to noon, Emotional Support Animal Legislative Update talks about the changes that were adopted in Florida this year regarding emotional support animals and how that's going to affect communities and how that ties in with the federal laws. Lisa McGill, along with Affinity Management Services, will be presenting that on August 11th, 11 a.m. to noon. Sign up for that on our website at kbrlegal.com. You can also sign up to have your name added to our email list of blasts there as well, and we suggest doing so. August 13th at noon to 1 p.m. With the Castle Group as our host, Jeff Rembaum and Lisa McGill will be participating in discussions that are focusing on operations and the COVID-19 situation. So that's always got large groups of people submitting questions, and good information comes out of those. They do those every 2 weeks. So the next one of that is August 27th, also at noon, with Michael Bender and Jeff Rembaum and Greg Vaughn from Castle Management. And then on August the 18th, there will be a 1-hour legal update at 1 p.m. That Allison Hertz will be presenting. And then on August 26th, just added, 10 a.m. to 11:30, 40-year recertification course discussing all the issues that communities face for the 40-year certification issues on the physical plants that consists of the buildings of the community. So very important topic and highly recommended. I'll sign up on kbrlegal.com, look for the calendar and the various prompts on the website to identify which course you want to participate in and enjoy.
Give everybody your phone number.
You can reach us at 800-974-0680, or you can write to us at info@kbrlegal.com, the initial KBRLEGAL.com, and we're very happy to reply and get you what you need.
You know what, Robert? We have the greatest listeners. The questions are just always so fine, and we're so blessed to have great listeners like we do. I mean, every first Thursday of the month, the lines are going crazy, and we get so many emails, questions, and people just love the way you do the show.
Well, we're happy to be here and look forward to talking to everybody again next month.
We'll be back next month. Thanks, Robert.
Thank you,
And
Steve.
we'll be more Ask the Experts on Monday from 6 to 7. Everybody have a good weekend. Stay safe, Robert.
You too.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.
The opinions expressed on the preceding sponsored program were strictly those of its host.